do want to point out that
And live now to a hearing on immigration policy relating to migrant children on the border and how to end incentives for illegal immigration. Justice Department and Homeland Security officials are testifying here before the Senate Homeland Security and Governmental Affairs Committee. This hearing just getting underway.
Obviously, it became pretty controversial, but we took a look at this in our committee in August, had a meeting with the committee to figure out what we can do to solve the issue about being able to enforce our immigration laws without having separating families. I don't think anybody wanted to do that. In that meeting, I proposed 4 basic goals I hope we could agree on. I'm not sure we have total agreement, but the goals that I proposed in trying to focus on fixing this problem. We're not talking about comprehensive immigration reform here, we're really talking about trying to fix this particular problem. But the 4 goals I laid out was, hopefully we all want to secure our border. I think a sovereign nation needs to do that. Enforce our immigration laws. Maintain reasonable asylum standards. And also keep asylum-seeking families together. I thought those were 4 reasonable goals. I thought we had a very good discussion in August. Senator McCaskill certainly pointed out, and other people on the Democrat side talked about, we really do need to take a look at alternatives to detention. Take a look at research, take a look at the cost effectiveness of that. I'm happy to do that. We held, I think, 21 briefings, bipartisan briefings with different groups in government and outside of government trying to take a look at that issue. So, again, this is all part of that problem-solving process. We're still gathering the information. I'm not sure we have all of it. And when you start taking a look at alternatives for detention, it's pretty complex. Don't have a whole lot of data on it. But I do want to start with just, a hearing chaired by me wouldn't be complete without some charts. So if we can put up our first chart here, just basically describing the problem. The first chart just shows the history of unaccompanied children coming to this country illegally from Central America. And you can take a look in 2009, 10, 11, on average, is less than 4,000 unaccompanied children came in from Central America. And then starting in 2012, we began a surge, with 2014 being the most dramatic surge year, but it really hasn't abated all that much. This is just an ongoing problem, and again, I would argue there's certainly things in our laws that have created an incentive for children to come in unaccompanied from Central America. Next chart. And this is really the chart that's describing the problem that we're trying to address here today in this hearing. This is family units coming to this country. You can see in 2012, we had a little over 11,000 family units coming to this country, and then 15,000, then 2014, together with that surge of unaccompanied children from Central America, more than 68,000 families surged across the border. The Obama administration recognized that was a problem, and so they began detaining families so they could adjudicate the claims, and those that had valid asylum claims obviously stayed. Those that did not have valid asylum claims were returned, and it had an effect. So in 2015, the number of families still unexceptionally high level, but it definitely dropped to 40,000. And then in July of 2015, through court action, the Flores settlement, which really dates back to 1985, we'll get a little bit of a history lesson, I'm sure, from our witnesses, was reinterpreted and really applied to accompanied children as well as unaccompanied children, and that really forced the Obama administration into a decision. Do we continue to detain people? Well, they simply couldn't detain do we detain the adult and be forced to release the child into HHS custody? They basically chose they weren't going to do that. It began a process of basically apprehending families that came to this border, not being able to detain them, and then releasing them into the interior. And we'll be, I'm sure, talking about the rates of deportation associated with not detaining individuals. That resulted in an incentive for more families coming in. You can see the results, 77,000 in 2016, 76,000 in 2017, and already this year, in just 11 months, we're up over 90,000 families. So again, this is a problem. Next chart. Now, I think it's pretty obvious that there are both push and pull factors at work here in terms of why people come to this country. You know, it's a land of unlimited opportunity. That's a huge pull factor, but there's also violence and really destruction in public institutions, certainly in Central America, because of our insatiable demand for drugs and the drug cartels. This is a chart that combines murder rates in Central America versus asylum claims. And I think what's interesting about this is even though murders have stayed relatively steady in terms of murder rates, very high, again, it's unacceptably high in Central America, asylum claims have shot up in the last couple of years. So there's some disconnect here in terms of cause and effect in terms of a push factor out of Central America. There's something happening, and I would say there's a lot of incentives here, and we'll talk about that, the Flores decision, the Trafficking Victims Protection Act. I mean, there are things that caused some incentives. Our next chart then. Again, the Obama administration realized they had a problem with family units. And so back in 2014 and 15, I think it was, Secretary of Homeland Security Jay Johnson commissioned a study by the Institute for Defense Analysis. And just looking at, and basically the name of it was describing the adjudication process for unlawful non-traditional migrants. This was published in June 2017. Again, this was commissioned by the Obama administration. I'd like to enter that into the record. But what it showed is the removal rate for detained illegal immigrants versus not detained. You can see it's a dramatic difference. And also how many were actually detained out of their sample versus not detained. You can see for those illegal immigrants that were detained, 77% were removed. For those that were not detained, only 7% were removed, which, again, creates an awful lot of incentive for more family units to come to this country. So I don't want to really go on too much longer here, but we just kind of laid the groundwork describing the problem. I would ask that my written opening statement be entered in the record. But I'll just close on saying that what we've really created here for Customs and Border Patrol, for ICE, for our law enforcement community is they have two options when it comes to dealing with people coming to this country illegally as a family unit, and both of them are bad. We either have to enforce the law and then force to separate parents from children, and nobody wants that to happen. Okay, that's no longer the policy, or revert to the Obama-era policy, which is what we're under right now, which is we apprehend these families, we can't hold them, we can't really determine parentage, and we release them into the interior at very low removal rates for those that don't have valid asylum claims. So again, I don't think that's an acceptable state of affairs. What we're trying to do in this committee is look at that one specific problem and try and fix that on I would call it a nonpartisan basis. Just take a look at the facts, deal with that information, try and set an achievable goal, and design a solution. And that's the purpose of this hearing, it's the purpose of our efforts, and I for one, hopefully, I hope we succeed. With that, I'll turn it over to Senator McCaskill.
Thank you. I want to recognize that witnesses before us today first and applaud the work you do. I know from my time as a prosecutor that law enforcement officials go to work each day not thinking about themselves, and frankly, sometimes not even thinking about their families, but rather how do we keep our communities safe and how do we keep each other safe. That's true of law enforcement officers of both CPB, Customs and Border Patrol, and ICE. The selflessness of service is also true of the immigration judges, public servants who work at DOJ, and the independent auditors, analysts, and watchdogs at GAO. I know firsthand that our federal law enforcement officers face real challenges in carrying out their jobs. I've seen the ingenuity of our Border Patrol agents as they built their own night vision surveillance vehicle by literally duct taping a surplus night vision goggles they got from the Department of Defense to a pole in the back of a pickup truck. I know that even though officers at ports of entry are the ones that are seizing the majority of the fentanyl and other opioids, they are still understaffed by CPB's own guidelines. I know our immigration court judges face a tremendous backlog. I also know that while overall illegal border crossings are at their lowest level in 30-plus years, following a decade-long trend, for the past few years, these agents and officers have been facing an increasing number of immigrant families trying to cross the border. There are a lot of different proposals for dealing with these families, but I think there's one thing we can all agree on a bipartisan basis, is we cannot lose the sight that they're families, and that they need to be dealt with as families. No one should be separating children from their parents. Beyond that, this is a complex problem. And my chairman likes to constantly say, we need to get the facts, we need to get the facts. I think any action on legislation at this point is premature because we don't have all the facts. Let's face it, if this were easy, we would have gotten this done a long time ago. I want to focus on the Flores decision today, that it does not allow DHS to detain families for long enough. I will say this unequivocally. We do not have enough facts to even consider indefinite detention of families, even if it were the right thing to do, which I do not think it is. We don't know enough. We don't know what it would cost. We don't know how many beds would be needed. We don't know how long the average detention would be. There is simply not enough information to consider indefinite detention. We've learned that Flores is not the only thing standing in the way. We've learned there aren't enough detention facilities. It would be incredibly expensive to add more. According to the briefings we received, ICE would need an additional 15,000 beds just to house the immigrant families for 30 days, at a cost of over $1.3 billion per year. This doesn't include the cost of additional personnel or the cost of construction. And frankly, it takes an average, a median of 128 days to process an asylum case in detention. If that is even close to how long those families will remain in detention, that $1.3 billion only represents a fraction of what the cost we would actually pay. We also know that it costs $320 a day per person to keep a family unit detained. It only costs $8.50 to monitor them electronically. If both programs or some other alternative results in families showing up at their immigration hearing, let's just say there's a lot of other border security needs we could be spending that money on. As a former prosecutor, I understand the balance we need to strike. This is all about securing appearance at court, and when people appear at court, being efficient and ready for deportation if that's the decision of the court. If you look at the facts around this issue, there may have been some electronic monitoring projects that were abandoned, but there is no reason to believe they don't work. The majority of people that are arrested for crimes in the United States of America are released pending their appearance at court. I have a great deal of experience with this. When I was the Jackson County prosecutor, we were under a federal court order about how many people we could have in our jail. So every day I had to make a decision as to who we let out of jail and who we kept in jail. And I guarantee you we spent a lot of time on figuring out how we monitored those people that got out and how we secured their appearance. We know how to secure people's appearance at court. There is technology and there is oversight, and both of them are less expensive than building billions of dollars of beds to hold families indefinitely because our system is so inefficient. How effective is the monitoring? It is very effective in this country. How efficient is the system? Our system on asylum determination and removal couldn't be more inefficient. We should be starting with a bill that requires electronic records. Do you know if they have to do a hearing in Texas and the file is in California, they have to FedEx the file? No system in this country is still all paper. No system in this country is still all paper, except this one. It is absolutely unbelievable to me that we are this inefficient. And we've been securing people's appearances at hearings, but the last hearing, when the asylum is determined, for some reason, after they've determined they don't get asylum, we're not monitoring them anymore. We need to be prepared at that last hearing. We need to have preparations, and the people coming need to know that if the case goes against them on asylum, they're going to be deported immediately. It is about efficiencies in the system. It is not about imprisoning families indefinitely in this country. So I think what we have to do is we have to deal with the shortage of immigration judges. We have to deal with the inefficiency in the system and how long it's taking to have these claims heard. That doesn't mean we should shortchange people on their claims. We should give them adequate opportunity to have their claims heard. But the fact that we are unwilling, we're willing to build more beds, but we're not willing to even hire the number of judges that have been funded. We don't even have enough judges now to even fill the number of judges we have given the Department of Justice. for asylum claim determination. So we're putting the cart before the horse. We are defaulting to the most expensive and nonsensical way to secure appearance when there is all kinds of ways in this country that we can secure appearance and make this system more efficient. And I stand ready and willing to work with the chairman of this committee and any Republican, making sure that we secure people's appearance at court. But we don't have to separate their families. For the first time in our country's history, go on a building program of family prisons. That is not the right answer. And I look forward to the witnesses' testimony and discussion about these issues as we move forward.
Thanks, Senator McCaskill. The good news is there's an awful lot of things we agree on in right there, and that's how we'll try and come up with some kind of solution here, those areas of agreement. I'd be remiss if I didn't point out the fact that we have a new member, Senator John Kyle from Arizona, who obviously in this issue, you're sort of the tip of the spear in terms of this problem. So again, really want to welcome you to the committee and look forward to your valuable input throughout all of our issues, but in particular this one here today, and appreciate you appearing here today. It is a tradition of this committee to swear in witnesses, so if you all stand and raise your right hand. Do you swear that the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated. Our first witness is Mr. Matthew Albence. Is it Albence? Albence, okay. Kind of had it right the first time. It's very unusual for me to get it right the first time. Mr. Albence is the Executive Associate Director for Enforcement and Removal Operations and the senior official performing the duties of the Deputy Director at Immigration and Customs Enforcement. Mr. Albence has over 24 years of federal law enforcement experience with Immigration and Customs Enforcement, Immigration and Nationalization Service, and the Transportation Security Administration. Mr. Albence.
Chairman Johnson, Ranking Member McCaskill, and distinguished members of the committee. Thank you for the opportunity to appear before you today to discuss the impact of the Flores Settlement Agreement on U.S. Immigration and Customs Enforcement's critical mission of protecting the homeland, securing the border, and ensuring the integrity of our nation's immigration system. Our nation's immigration laws are extremely complex and in many cases outdated and full of loopholes. Moreover, the immigration laws have been increasingly subject to litigation before the federal courts, which has resulted in numerous court decisions that have made it increasingly difficult for ICE to carry out its mission. The current legal landscape often makes it difficult for people to understand all that the dedicated, courageous, professional officers, agents, attorneys, and support staff of ICE do to protect the people of this great nation. To ensure the national security and public safety of the United States, our ICE personnel faithfully execute the immigration laws enacted by Congress, which may include enforcement action against any alien encountered in the course of their duties who is present in the United States in violation of immigration law. Since the initial surge at the southwest border in FY 2014, there has been a significant increase in both the arrival of family units and unaccompanied alien children at the southern border, a trend which continues despite the administration's enhanced enforcement efforts. Thus far in FY 2018, as of the end of August, approximately 53,000 UACs and 135,000 members of alleged family units have been apprehended at the southern border or deemed inadmissible at ports of entry, a marked increase over FY 2017. Most of these family units and UACs are nationals of the Central American countries of El Salvador, Guatemala, and Honduras. Pursuant to the Trafficking Victims Protection Reauthorization Act of 2008, UACs from countries other than Canada and Mexico may not be permitted to withdraw their application for admission, further encumbering the already overburdened immigration courts. With an immigration court backlog of over 700,000 cases on the non-detained docket alone, it takes years for many of these cases to work their way through the immigration court system. And few of those who receive final orders are ever actually returned to their country of origin. In fact, only approximately 3% of UACs from Honduras, El Salvador, or Guatemala encountered at the southwest border in FY 2014 had yet to be returned or removed by the end of FY 2017. One of the most significant impediments to the fair and effective enforcement of our immigration laws for family units and UACs is the Flores Settlement Agreement. Since it was executed in 1997, the Flores Settlement Agreement, which was intended to address the detention and release of unaccompanied minors, has spawned over 20 years of litigation regarding its interpretation and scope, and has generated multiple court decisions resulting in expansive judicial interpretations of the original agreement in ways that have severely limited the government's ability to detain and remove UACs as well as family units. Pursuant to court decisions interpreting the FSA, DHS can generally only detain alien minors accompanied by a family member in a family residential center for approximately 20 days. And the TVPRA generally requires that DHS transfer any UAC to the Department of Health and Human Services within 72 hours. However, when these UACs are released by HHS or family units are released from DHS custody, many fail to appear for court hearings and actively ignore lawful removal orders issued against them. Notably, for family units encountered at the southwest border in fiscal year 2014, as of the end of fiscal year 2017, 44% of those who remained in the United States were subject to a final removal order, of which 53% were issued in absentia. With respect to UACs, between the beginning of FY 2016 and the end of June FY 2018, nearly 19,000 UACs were ordered removed in absentia, an average of approximately 568 UACs per month. This issue has not been effectively mitigated by the use of alternatives to detention, which has proved to be substantially less effective and cost-efficient in securing removals than detention. While the ATD program averages 75,000 participants, in FY 2017, only 2,430 of those who were enrolled in the program were removed from the country. This accounts for only 1% of the 226,119 removals conducted by ICE during that time. Aliens released on ATD had their cases heard on the non-detained immigration court dockets, where cases may linger for years before being resolved. Thus, while the cost of detention per day is higher than the cost of ATD per day, because those enrolled in the ATD program often stay enrolled for several years or more, while those subject to detention have an average length of stay of approximately 40 days, the cost of ATD outweighs the cost of detention in many cases. Nor are the costs of ATD any more justified by analyzing them on a per-removal basis. To illustrate, in FY 2014, ICE spent $91 million on ATD, which resulted in 2,157 removals. By FY 2017, ICE spending on ATD had more than doubled to $183 million, but only resulted in 2,430 removals of aliens on ATD, an increase of only 273 removals for the additional $92 million investment at an average cost of $75,360 per removal. Had this funding been utilized for detention, based on FY 2017 averages, ICE could have removed almost 10 times the number of aliens as it did via ATD. Moreover, because family units released from custody and placed on ATD abscond at high rates, rates significantly higher than non-family unit participants, many family units must be apprehended by ICE while at large. Such at-large apprehensions present a danger to ICE officers who are the victims of assaults in the line of duty at alarmingly increasing rates. Specifically, in FY 2018 through July 31st, the absconder rate for family units on ATD was 27.7%, compared to 16.4% for non-family unit participants. Most of these aliens remain in the country, contributing to the more than 564,000 fugitive aliens on ICE's docket. Unfortunately, by requiring the release of family units before the conclusion of immigration proceedings, seemingly well-intentioned court rulings like those related to the FSA and legislation like the TVPRA in its current form create loopholes that are exploited by transnational criminal organizations and human smugglers. These same loopholes encourage parents to send their children on the dangerous journey north and further incentivizes illegal immigration. As the record numbers indicate, these loopholes have created an enormous pull factor. To address these issues, the following legislative changes are needed. Terminate the FSA and clarify the government's detention authority with respect to alien minors, including minors detained as part of a family. Amend the TVPRA to provide for the prompt repatriation of any UACs who are not victims of human trafficking and do not express a fear of return to their home country, and provide for similar treatment of all UACs from both contiguous or non-contiguous countries to ensure they are swiftly and safely returned to their countries of origin. Amend the definition of special immigrant juvenile to require that the applicant demonstrate that reunification with both parents is not viable due to abuse, neglect, or abandonment, and that the applicant is a victim of human trafficking. The current legal requirement is simply not operationally viable. Address the credible fear standard, a threshold standard for those subjected to expedited removal to be able to pursue asylum before the immigration courts. The current standard has proved to be ineffective in screening out those with fraudulent or frivolous claims, and it thus creates another pull factor and places a strain on the system that inhibits the government's ability to timely address meritorious asylum claims while allowing those without valid claims to remain in the United States. Thank you again for the opportunity to appear before you today and for your continued support of ICE and its essential law enforcement mission. We continue to respond to the trend of family units and UACs who are apprehended while illegally crossing the United States, and to address this humanitarian and border security issue in a manner that is comprehensive, coordinated, and humane. Though DHS and ICE are continuing to examine these issues, ongoing litigation and recent court decisions require a permanent fix from Congress to provide operational clarity for officers in the field and to create a lasting solution that will secure the border. Congress must act now to eliminate the loopholes that create an incentive for new illegal immigration and provide ICE with the lawful authority and requisite funding needed to ensure that families can be detained together throughout the course of their immigration proceedings. Most family units claiming to have a fear of returning to their home countries are ultimately not granted asylum or any other relief or protection by immigration judges. And it is imperative that ICE can ensure that when such aliens are ordered removed from the United States, they are actually removed pursuant to the law. I'd be pleased to answer your questions.
Thank you, Mr. Albence. Our next witness is Mr. Robert Perez. Mr. Perez is the Acting Deputy Commissioner with Customs and Border Protection. Mr. Perez started his career with the U.S. Customs Service in 1992 as a customs inspector and has served in a variety of operational leadership positions within the Customs Service and Customs and Border Protection. Mr. Perez.
Chairman Johnston, Ranking Member McCaskill, and distinguished members of the committee, it's my honor to appear before you today on behalf of U.S. Customs and Border Protection. Every day, the men and women of CBP facilitate legitimate travel, screening more than 1 million international passengers and pedestrians. Every day, we process an average of $6.5 billion worth of imported goods. Every day, CBP seizes nearly 6,000 pounds of narcotics and arrests 21 wanted criminals. Every day, we protect our borders from terrorists, identifying more than 1,600 individuals with suspected national security concerns. Every day, we guard our nation's food supply, discovering over 350 pests and more than 4,300 materials for quarantine at our ports of entry. Every day, CBP's employees work to make our nation safer and our economy more competitive. CBP has a vast and complex mission that affects the lives of every American every day. I'm honored to represent the hardworking men and women of CBP, whose work is often difficult and dangerous and critical to our national security. And I'm also grateful for this opportunity to share what they are experiencing in the field. As the guardians of America's borders, the men and women of CBP are on the front lines of our country's migration crisis. While many factors do contribute to an individual's decision to attempt a dangerous journey to the United States, we cannot ignore the role our country's immigration laws play in enticing illegal entry, subverting the rule of law, and encouraging manipulation of the system. There is a perception among some migrants that children and families are treated differently than individual adults, and our operations, at times governed by the laws and judicial interpretations, resulting in legal loopholes, do not dispute this perception. As a result, we've seen an alarming spike in the number of family units we encounter. Last month, the number of family unit aliens apprehended at our border or deemed inadmissible at our ports of entry increased by 38%, 3,500 more than July of this year, and the highest number on record for the month of August. No matter how well-intentioned, these laws and policies, including the Flores Settlement Agreement and the Trafficking Victims Protection Reauthorization Act of 2008, or TVPRA, have an operational impact on CBP's ability to fulfill its mission and uphold the rule of law. For example, the Flores Settlement Agreement limits the government's ability to detain family units through their immigration proceedings. This means that adults who arrive in this country alone are treated differently than adults who arrive with a child. Given the time frame associated with the immigration process, that means that more times than not, families are released from custody. This has created a business model for smugglers that at times places children into the hands of adult strangers so they can pose as families with the hope of being released from immigration custody once they cross the border. There are similar unintended consequences associated with the TVPRA. In order to comply with the TVPRA, CBP prioritizes unaccompanied alien children for processing before transferring them to the custody of the U.S. Department of Health and Human Services. However, increases in apprehensions severely limit HHS's ability to quickly place unaccompanied alien children with adequate sponsors or place them in long-term shelters. In addition, elements of the TVPRA encourage trafficking organizations to smuggle unaccompanied alien children into the U.S., knowing they will eventually be released to sponsors. Ultimately, enforcement of our immigration laws is the foundation of a secure border and a secure nation. At times, well-intentioned actions have had unintended negative consequences on the immigration system as a whole. DHS leaders, including CBP, have worked closely with members of Congress to address these immigration loopholes that affect our national security. I look forward to continuing our work with the committee toward this goal. Thank you for the opportunity to appear before you today, and I look forward to your questions.
Thank you, Mr. Perez. Our next witness is Mr. Joseph Edlow. Mr. Edlow is the Acting Deputy Assistant Attorney General at the Department of Justice. Mr. Edlow serves in the Office of Legal Policy, working on a variety of issues, including immigration. Mr. Edlow served for 6 years as an Assistant Chief Counsel at Immigration and Customs Enforcement. Following that, he worked for the House Judiciary Committee. Mr. Edlow.
Thank you, Mr. Chairman. Chairman Johnson, Ranking Member McCaskill, and other distinguished members of the committee. Thank you for the opportunity to speak with you today regarding the Department of Justice's position on the Flores Settlement Agreement. The Flores Settlement Agreement, or FSA, was reached in 1997 after 12 years of litigation. The agreement set nationwide procedures and conditions for the care, custody, and release of unaccompanied minors, including to whom these minors may be released. At the time, this agreement served as the framework for handling immigration matters related to unaccompanied minors. The FSA also served as the basis for the William Wilberforce Trafficking Victims Protection Reauthorization Act of 2008, or TVPRA, which, like the FSA, does not address accompanied aliens. The agreement remained in effect through the dissolution of the INS and the passage of the Homeland Security Act, which formally created the Department of Homeland Security and transferred responsibilities for care and custody of unaccompanied alien minors to Health and Human Services. It was interpreted several times since 1997, including in 2015 when the U.S. District Court for the Central District of California found that the agreement was applicable to all alien minors without legal status, including those encountered with a parent or guardian. Based on this interpretation, the court therefore explained that the FSA required that accompanied minors must be transferred to a licensed facility as expeditiously as possible. The previous administration unsuccessfully appealed these rulings, and the courts were warned in 2015 that this expansion of the agreement could lead to the separation of accompanied children from their parents in order to comply with the new interpretation. After the initial entry of the agreement, Congress passed legislation which the government argued largely superseded the agreement, including the Homeland Security Act of 2002 and the TVPRA. However, regardless of the efforts by previous administrations, the court found that these statutes did not supersede the agreement. On June 21st of this year, pursuant to an executive order, the Department of Justice requested a modification of the agreement to permit DHS to detain alien families together throughout immigration proceedings, which was ultimately denied by the district court. Despite the agreement's requirement that a child must be transferred from a secured, unlicensed ICE or CBP facility as expeditiously as possible, it is generally legally and practically impossible to complete immigration proceedings in the 20 days that have typically been used as a guidepost. The pending immigration court caseload increased by nearly 470,000 cases, or 350%, between 2008 and 2017, in part due to surges in illegal immigration, which accompanied changes in immigration policies and reinterpretations of prior law. Nevertheless, the Executive Office for Immigration Review, or EOR, has taken steps to address the increased caseload, including by hiring more immigration judges and moving forward with a long overdue electronic filing and case management modernization effort. The Department of Justice appreciates the opportunity to work with the Department of Homeland Security, the Department of Health and Human Services, and Congress to address these challenges and improve our immigration system. The outdated Flores Settlement Agreement constitutes a roadblock to solutions for keeping families together once encountered at the border, and the Department believes that the best path forward is through legislation aimed at terminating the agreement, returning to the rule of law, and enforcing our nation's immigration laws. Additionally, DHS and HHS's proposed regulations will, in the absence of legislation, ultimately serve the best interests of all alien minors and their families. Thank you for this opportunity to speak with you today, and I look forward to your questions.
Thank you, Mr. Edlow. Our final witness is Ms. Rebecca Gambler. Ms. Gambler is the Director for Homeland Security and Justice with the Government Accountability Office. Ms. Gambler leads GAO's work on border security, immigration, and election issues. Ms. Gambler.
Good morning, Chairman Johnson, Ranking Member McCaskill, and members of the committee. Thank you for the opportunity to appear today to discuss GAO's work on the immigration courts and the Alternatives to Detention program. Within the Department of Justice, the Executive Office for Immigration Review, or EOR, is responsible for conducting immigration court proceedings to uniformly administer and interpret U.S. immigration laws and regulations. In June 2017, we reported on EOR's management of the immigration courts. As part of that report, we took a look at EOR's caseload. From fiscal year 2006 through 2015, EOR's caseload grew 44% from approximately 517,000 cases in fiscal year 2006 to about 747,000 cases in fiscal year 2015. This increase was attributable primarily to an increase in the case backlog. From fiscal years 2006 through 2015, the immigration court's backlog more than doubled, reaching a backlog of about 437,000 cases pending in fiscal year 2015. We also reported on how EOR was overseeing and managing immigration court operations, and we identified a number of challenges related to workforce planning and hiring, among other things. For example, during the time of our review, EOR estimated its staffing needs using an informal approach that did not account for long-term staffing needs or reflect EOR's performance goals. We recommended that EOR develop and implement a strategic workforce plan. Moreover, during our review, we found that EOR did not have efficient practices for hiring new immigration judges, which contributed to staffing shortfalls. Our analysis showed that from February 2014 through August 2016, EOR took an average of 647 days to hire an immigration judge. We recommended that EOR assess its immigration judge hiring process and implement actions identified through such an assessment. EOR generally agreed with our recommendations in these areas and is taking action toward addressing them by, for example, working on a strategic plan that includes human capital planning and working to streamline the hiring process. We will continue to monitor EOR's progress in responding to our recommendations to address the agency's longstanding challenges. With regard to the Alternatives to Detention program, in November 2014, we reported on how U.S. Immigration and Customs Enforcement, or ICE, managed the program. ICE implemented the program in 2004 to be a cost-effective alternative to detention that uses case management and electronic monitoring to ensure foreign nationals released into the community comply with their release conditions, including requirements to appear at immigration court hearings and to comply with final orders of removal from the country. At the time of our review, the program was comprised of two components, one managed primarily by a contractor and another managed by ICE. The number of foreign nationals who participated in the Alternatives to Detention program increased from about 32,000 in fiscal year 2011 to over 40,000 in fiscal year 2013. This increase was attributable to increases in enrollments and the average length of time foreign nationals spent in the program. We also looked at the cost of the Alternatives to Detention program. We found that the average daily cost of the program per person was $10.55 in fiscal year 2013, while the average daily cost of detention per person was $158. While our analysis showed that the average daily cost of the program was significantly less than the average daily cost of detention, the length of immigration proceedings affected the cost effectiveness of the Alternatives to Detention program over time. Further, at the time of our report, ICE had two performance measures to assess the program's effectiveness. One, compliance with court appearance requirements, and two, removals from the United States. For the first measure, for the component of the Alternatives to Detention program managed by the contractor, data from fiscal years 2011 through 2013 showed that over 99% of foreign nationals with a scheduled court hearing appeared at their scheduled court hearings while participating in the program. For the second measure, the program met its goals for the number of removals in fiscal years 2012 and 2013. However, we identified limitations in data collection that hindered ICE's ability to assess overall program performance, in part because ICE did not consistently collect performance data for both components of the program. We recommended that ICE strengthen its data collection, and ICE took action to implement that recommendation. This concludes my prepared statement, and I'm happy to answer any questions members may have.
Thank you, Ms. Gambler. Again, I first of all appreciate attendance here by my colleagues, and so out of respect for their time, I'll defer my questioning till the end. So I'll turn to Senator McCaskill.
When somebody correct me if I'm wrong, when folks are monitored, the majority show up, correct?
ATD has proven to be fairly effective at getting people to appear for appearances with ICE and appear for some court hearings, yes.
Okay. And after asylum has been denied and a removal order has been entered, the majority of them are no longer monitored, correct?
Many of them are not monitored up to the point of the removal order. Well, first of all, there's cost. It would be expensive to monitor them throughout the pendency, as some of these hearings go for 4, 5, 6, 7 years. Many individuals that get these removal orders actually get them in absentia because they've absconded.
But here's my point, Mr. Albans. What I'm trying to say is, if we know monitoring gets them to court, and if the problem is after they know they're not going to get asylum, they no longer show up, it seems to me that we need to focus monitoring at that place. Now, let me continue.
Well, but if I could answer that question, that's when those individuals will abscond, whether if they had a bracelet on, as we've seen with many individuals now, especially those family units, they will cut those bracelets.
But the majority of them are not even getting those bracelets once that they have been denied asylum. The vast majority aren't even getting bracelets. Nobody's paying attention to them.
No, ma'am, we have a contractor that does a significant amount of work tracking these cases and monitoring them. As GAO just indicated, our metrics are very good with regard to how we track these cases, how we're able to monitor them.
I think you do, but not after the asylum has been denied. I think that's the problem. Let me go further with this. Mr. Edlow, is there any reason in the law that you could not organize asylum hearings around country of origin?
I don't know that that's ever been considered. You know, certainly the department and EOR takes every case on a case-by-case basis, and the immigration judge makes that adjudication, that determination on a case-by-case basis. I don't know, given all the factors that would be in play there, that we would be able to organize it around the same country.
Well, it seems to me that the vast majority of these cases are coming from a handful of countries. Seems to me that it would not be beyond reasonable to try to organize these court hearings around countries, especially if you had enough judges to do it earlier than 2 or 3 years. And why couldn't you monitor people until that hearing, and then when they show at that hearing, then they're deported right then?
Well, they would have a 30-day appeal period, during which time they could appeal the ruling of the judge.
And they could be monitored.
They could be monitored, but again, our experience has shown is once individuals will comply with their reporting requirements up until the point where there is no benefit of them doing so. So once they no longer are going to obtain that benefit or have a denied asylum claim, that is when individuals will generally abscond. They will comply up until the point where the benefit of complying is no longer there.
But I guess what I'm saying is, you know, it reminds me of how we got people to court when they were charged with a crime. And we would never dream of, after the jury had found them guilty and they were sentenced, we would never dream of deciding that would be the least intensive time of monitoring. And the data shows that there is not as intensive monitoring at that point in the process as there is for their initial appearance.
Again, we are experiencing a significant rate of absconders among the family units. Nearly 3 in 10 family units are cutting off their ankle bracelets at the beginning of the process when they've been released from our custody within days or weeks. So they are not even going to get to that point where they would get a final removal.
Do we have the resources when they cut off those bracelets to pick them up?
Absolutely not. ICE has not been given resources to go out and effectuate these at-large arrests in many years. I have 129 fugitive operations teams within ERO, and most of their time is spent going after criminal aliens and public safety threats. I simply do not have the resources to get people once they're at large in the communities.
Well, it seems to me that this is a court appearance problem, and we ought to figure out a way to make court appearances more likely. And there are all, I mean, believe me, when you're facing prison, you don't want to go to court. But we have a very low rate of absconding in the criminal justice system compared to this system. So I think we can learn lessons there. For one, you hire enough judges to handle the caseload. And Mr. Edlow, can you explain why you can only hire 100 judges a year?
Well, since the beginning of this administration, we have hired, over 128 judges.
Why does it take, why can't you hire more?
Well, first it took a while to get the authorization. Now I realize that based on what you said, that we do have the authorization, but, and I believe Mr. McHenry spoke to this at the last hearing, it's not just a matter of getting the judges. The judges are important, but it's having the facilities for those judges. It's having the courtrooms. It's having appropriations so that we can have the appropriate staff, the video teleconference system, if that's the way that the hearings are going to be handled. And frankly, it's also appropriations to ensure that ICE is able to provide a trial attorney to those hearings. The Department of Homeland Security is a party to these hearings, and we need to make sure that they're represented there as well. So,
but wouldn't this be a better investment than building family prisons? Wouldn't that be a better investment of hiring personnel? And I guarantee you there's all kinds of places. I've seen hearings in amazing places, especially when they're done with video. You know, it seems like to me we're throwing up roadblocks when the real problem is we have not invested in a system in terms of adequate personnel to actually handle these claims. The longer this goes on, the more likely it is they abscond. I don't think that anybody will argue with me about that. That the longer this goes on, the less likely we're going to be monitoring and knowing where people are that are supposed to go to court. And this is a process that people need to comply with. It's the law. So I think we need from DOJ exactly what your excuses are that you cannot, and give us the numbers. Because people are considering building family prisons, and I know how expensive that is. That's contractors as far as the eye can see. If we're going to go about building family prisons in this country as a new policy initiative, I would much prefer to do the hard work of getting the resources in place for the infrastructure of a judicial system as it applies to immigration that could work in a timely way. It's outrageous that people are waiting 6 and 7, or let me be more fair, 3 to 4 years for a hearing. No wonder we can't keep track of everyone. 3 to 4 years is a long time. And you know, this is one of those issues that I think we need more input from justice as to why it is specifically. If it's resources, I guarantee you we can get bipartisan support to get you more resources for this. Most of us would much rather spend the money on this than building family prisons. Thank you, Mr. Chairman.
So I want to quick interject here because I think it'll help our hearing moving forward to really get clarity on the whole judicial process here, okay? And this is how I understand it, and please correct me, and I want you to really clarify this. So you really have, first of all, two distinctions. You have the detained docket and the non-detained docket, correct?
that's correct.
And the detained docket has a priority given to it.
We work with DHS to prioritize the detained docket.
But I mean, it's a dramatic difference in terms of the initial completion as well as any kind of appeals and everything else. So the final adjudication occurs much quicker on the detained docket versus the non-detained.
That's correct, Mr. Chairman.
Addresses, they've got family, they've got, you know, ways of finding them, and a lot more resources, by the way, to track them down versus the illegal population that necessarily don't have families, that it's actually pretty easy for them to cut their bracelets and just blend into society.
That's correct. I'm not aware of any criminal justice system in this country that has a docket size over 700,000.
So again, we're just overwhelmed by the numbers, and there's a difference between the illegal immigration population versus our normal criminal justice system in terms of being able to track them down, the resources to track them down if they were to abscond from an alternate to detention.
There's a huge difference with regard to that. There's also a huge difference with regard to our ability to locate these individuals. Individuals that are here in the country lawfully will have numeric identifiers that we can utilize to locate them. They have utility bills, they have social security numbers, they have driver's license numbers. That's how we conduct investigations to locate people. When you have people that are just here illegally in the country and there is no investigative footprint, our ability to try to identify those people and locate where they are is very limited, very time consuming, and very resource intensive.
So my final point or final question is then, because I've seen so many numbers, I mean, that's why I'm trying to simplify this as best I can, very complex situation. In terms of the average length to final deportation order where we can actually remove them, where there's no longer appeals, so that's part of the problem too, is they get what they call a final order, but then they can appeal it, and that's when they abscond. How long is that on average on the detained docket versus the non-detained docket? Anybody have a good number on that? Mr. Edlow?
Mr. Chairman, first I would just note that if they're on the detained docket, they probably can't abscond since they're in detention. So there is no lag time in that. But certainly it's taking an average right now to complete a non-detained case of 752 days. So, and then after that, I would have to defer to the Department of Homeland Security after that period of time, how long it would take to get the travel documents and effectuate the removal.
But, so that's less than 2 years. I've seen much longer figures, kind of depending on the court too. We've seen it going 4 to 5 years.
Well, certainly the dockets vary. The crowdedness of each docket would vary based on the location of the court and what that court is typically handling it.
So what about on the detained docket? What is the length of time on average? Yeah, I've seen initial determination like 41 days, and that's up quite a bit. But
that's exactly.
What about to the final point of removal?
I can just tell you where we are in terms of completing the case, and then I would have to defer to ICE on that. But 40 days is correct.
Generally, removal to one of these, to Mexico or one of these Northern Triangle countries is quite rapid. We work very closely with the consular officials in these countries. We also actually had them on site in many of our facilities. We can get travel documents in many cases between 3 to 7 days. And I will confirm what Mr. Edlow said, that our absconder rate for aliens in detention is 0.
Okay. Well, magically, my 7 minutes is still there, so I think I'm getting close to it. So we'll go to Senator Portman.
Thank you, Mr. Chairman. And this is a really important hearing. It's a tough issue, really difficult issue, because we're balancing kids coming into our country who we all have compassion for with our immigration system, families coming in, infrastructure that is inadequate to deal with it, and we've talked about that today with 700,000 pending cases. There's nothing like this, as Mr. Almas just said, in the criminal justice system in this country, certainly. 700,000 cases pending, and with regard to unaccompanied kids, I think it's about 70,000, is that right? Mr. Edlow, do you know?
It's around 80,000, sir.
80,000. So, look, this is challenging. I got involved in this issue, as some of you know, a few years ago when we had 8 individuals from Guatemala who were sent by HHS from detention, HHS care, to traffickers, actually the same traffickers who had brought them up from Guatemala as their sponsors. Those traffickers then took them to an egg farm in Ohio where they were exploited and put into a forced labor situation. I want to thank DOJ this morning because we just learned this morning that the 7th defendant in the Marion case pled guilty yesterday to trafficking charges. And, you all have been aggressive in going after these traffickers, and I appreciate that. But the problem is when these children come in, and now when the families come in and the children are in HHS care, they then go out to these sponsors without adequate screening. That's certainly what our research has found over the last few years. And we have a legislative initiative that some of us on this committee, in fact, my 2 colleagues to the right, Senator Carper and Senator Langford, are very involved in this, are going to be shortly introducing, which we think will really help to put somebody in charge, have some accountability, for 2 reasons. One, to ensure these kids are properly treated, that we don't send them out with traffickers, but second, to get them to their court hearings and to ensure the immigration system is working. We learned that late last year there was a call that went out, a 30-day call that the Trump administration had initiated, which frankly was not done in the Obama administration, so that's a positive step, at least to have a call going to these sponsor families to say, what's going on, where are the kids, and that some of you heard this number that 1,500 kids were unaccounted for. We'll have some new data we'll release later today probably, which shows that hasn't gotten much better. And a number of kids, a couple dozen, had left altogether, had run away from their families. So Part of the problem is the fact that we don't have this infrastructure in place to deal with it. And again, it's not easy to put it together, but it seems to me there are two things that we should all agree on. One is to deal with the push factors, particularly in the Northern Triangle countries, because if we continue to have this push to the United States, we're going to continue to have enormous challenges, regardless of what kind of infrastructure we put in place. And second, we need to ensure that we have more judges, more expedited proceedings. As was said by the chairman and the ranking member, if you have these long wait periods, a couple of years, it's far more likely you're going to have problems. And we've seen this in all of the data as we compare the detained versus the non-detained individuals and going to court. A couple of questions, if I could, and Ms. Gamble, you talked a little about this, the enormous backlog, the reasons for it. But Mr. Edlow, you're with Department of Justice, so tell us a little more about this. If we allow detention of family units together, what would that do to the detained docket?
Well, certainly, Senator, it would add additional cases to the detained docket, as if we were not bound by the Flores settlement agreement, those cases could move forward on that docket as opposed to being released and placed on a non-detained docket. The department would prioritize its resources and its judges to ensure that we continue to not have a backlog on the detained docket. We do not have a backlog now. We would not have a backlog then. The problem in speculating too much as to how it would ultimately look, perceptions matter. So if there is a change, a legislative change, or a termination of Flores, that would ultimately allow for the detention of family units together during their immigration court proceedings, that probably is going to cut off one of the pull and push factors that you just alluded to before. So that may affect apprehensions. I can't speculate on whether that would, but certainly the department would put the resources that it has and that it will continue to gain to ensure that we can hear those cases. And I should note that the department has been working already very, very closely with the Department of Homeland Security to prioritize family cases and to ensure that those cases can be expedited, not accelerated. We want to make sure that the process is there as Congress has intended, and we want to make sure that the law is being enforced evenly and fairly, but we want to make sure that these cases are heard quickly. And we can do that now, and we will continue to do that.
I think it's important to prioritize those cases for all the reasons you said, but we also have to prioritize all the cases. In other words, we need to bring the backlog down for everybody. And again, 700,000, you talked about the number of days you talked about, which is about 2 years on average, even to get someone to court. And you talked about the fact that there is an appeal process after that. And let me ask you this, and maybe this goes to the entire panel. Have you given us a number? How much would DHS and DOJ need to be able to substantially reduce that backlog, let's say by half, over a period of a couple of years? What resources would be required?
Senator, I would
and I give this to DHS as well.
I would have to work with our team and come up.
Would
with
you do that? Because I think
Senator.
that's sort of the question all of us are asking ultimately. One, how do you avoid the push factor and do more in Central America to avoid so many people coming here without documents and having this system that is going to be tough, as I said, no matter what. But then just dealing with the infrastructure, what kind of resources are required? As Senator McCaskill said, a lot of us, we want to put more funds into that than to other things. That may be true, because if you could, in fact, expedite these cases, it's much more likely they can be handled properly, and that we aren't going to lose people in the system, which is currently happening, and you aren't going to have issues that we talked about earlier of HHS actually putting kids into dangerous situations with sponsors who there is no accountability for. And by the way, that needs to be dealt with no matter what. I'm not going to get into that in this hearing because that's a separate topic, but we've got to get somebody responsible and accountable.
Senator, if I could add, in addition to adding the judges, ICE is in desperate need of attorneys to actually prosecute these cases. So if you only front load the judges, you're still going to have a bottleneck within ICE, because we need the attorneys and the support staff within our legal department to help prosecute these cases.
On both sides.
And we would need, obviously, officers to manage these cases. But in fact, the FY18 appropriations bill that gave us some additional attorneys, I believe it was 72, the appropriations language actually prohibited them from working on immigration cases. So we've got to be able to get the immigration
Mr. Edlow, Mr. Alderman, so I would just ask, and I'm sure the chair would appreciate this, and ranking member, just give us a number based on reducing the backlog by half within 2 years. What would that take? Thank you, Mr. Chairman.
And again, I would, total resources, specified, detailed out, everything you need. Senator Peters.
Thank you, Mr. Chairman. Thank you to our witnesses for being here today. I've been listening to the testimony, and I'm just trying to clarify in my mind some of the numbers that have been thrown around here. So if you could help me with that, I'd appreciate it. Mr. Albans, in particular, you've talked about folks who are in alternative programs and then don't show up for cases, or once there's an adjudication, immediately leave. And yet I'm looking at numbers here, so help me through this, that shows the data that families on ICE's main alternative detention program attended 99.6% of their hearings in the first half of 17, and ICE reports an overall success rate of 95.7. And a study of the Family Case Management Program, which is the high-touch caseworker-based alternative pilot for families, shows that 99% of families complied with court appearances and ICE appointments. So, folks, it seems, at least from this data, do appear for their court appointment with 95 to 99% of the time. Is that accurate?
Sure, it is accurate, but there are a lot of caveats to that. Many of these individuals, because the docket is so long, it's only measuring their compliance with one hearing or one court appointment, because they may have 4 or 5 resets or continuances that it does not measure. You're only tracking a small period of time. So over the long run, what we know is our absconder rates for family units in this year is 28.4%. Last year was 23%. In 2016 was 31%, and 2015 was 25%. Those are hard, firm numbers. With regard to family case management was a well-intentioned program that, again, the goal was to ensure compliance with court hearings. Overall, its compliance rate was a little bit less than our normal program at a much higher expense, and ultimately only resulted in 15 removals from the country at a cost of $1.16 million per removal. It's a very expensive program with no removals attached to it at the end.
So this figure of 99% for the Family Case Management Program, you said is flawed because it only has the first hearing?
In some cases, I would have to look at FCMP. Many of those individuals, the program, they probably never even completed their case before the program was dropped because of the expense and the inefficiency with actually removing people and getting the compliance with removal orders.
Well, we'll have to do a deeper dive then, because these are the numbers that have been presented to me. And you talk about the measurement of the program is removals. Now, these are folks who went through a court process looking for asylum. Do you think perhaps they were successful because they had a good argument to make and a successful case? Should we be looking at facts related to folks actually were here on legitimate reasons associated with asylum, that we shouldn't just look at removals as the standard measure of success or not?
Well, again, ICE is in charge of the immigration enforcement. Our goal is to enforce the laws and comply with the judge's order, whether that judge's order is a grant of asylum or whether that judge's order is a removal. The vast majority of individuals who, even though they surpass the credible fear threshold upon apprehension and their initial screening by CIS, ultimately, many of them do not ever actually file for asylum. And even those that do file, I believe the approval rate is in the 20% range. I don't have that exact number in front of me, but I believe it's in the 20% range. So the vast majority of these people we're talking about are not people with successful asylum claims.
Certainly with the detention docket, or the detained docket, in 40 days we process folks, get them out. That's pretty quick. And I agree with what I've heard from my colleagues earlier, that we've got to be able to have a process that moves that quickly for everybody by hiring judges, having the infrastructure in order to do it. But if I look at some of these costs associated with alternative programs as well, that based on the significant reduction in cost that the GAO has identified, that it would take 1,229 days of be waiting for an adjudication in an alternative program before it was more expensive than the detained. Mr. Edlow, you mentioned the average is 752 days, so it seems alternative programs from just a cost-benefit analysis are significantly cheaper. But let's move the process along. That's not making that argument. I think we need to be moving this process along a lot quicker. But let me, in my remaining time, I just want to mention something that I think is very important, and that is what our top priority in all of this should be, and that's the welfare and care of children who are in this process. A host of medical organizations, including the American Academy of Pediatrics, the American College of Emergency Physicians, the American College of Physicians, the American Medical Association, the American Psychological Association, and on, to name a few, have all concluded that there's irreparable physical and mental harm done to children who are placed in detention. Even brief stays in detention, according to these folks, can lead to psychological trauma and lasting mental health risk. So my question to really the panel is, in proposing rollbacks to the Flores settlement agreement, has DHS reviewed the extensive literature discussing the long-term health consequences that detention will have on children? Mr. Albence, you want to start?
The regulation writing process was very extensive. I was not personally involved in a whole lot of that, so I can't speak to all of the things that were reviewed during the course of that process. What I can tell you is that the family residential centers are humane. What we are looking to do with that regulation is not change the standards which we currently maintain. The purpose of the regulation is not to change the standards that we have that are currently exist. The purpose of the regulation is to bring us into compliance with the Flores settlement agreement, which was contemplated by the court, and that is the purpose of the regulation.
How long is too long, do you think, to detain a child in a detention facility?
I'm certainly not qualified to answer that question, sir.
Has your agency looked into that and thought about it and reviewed the literature associated with that?
I don't know. I could find out and get back with you.
I'd appreciate that. Anyone else like to comment about the review of your organization as to the psychological impact on children who are detained? Mr. Perez?
Senator, I'm not aware that with respect to CBP's particular review of the findings in the report, but we could certainly get back to you on that. I would just echo my colleague's sentiment that with respect to CBP's disposition, when it is that we do encounter children, their health and well-being is first and foremost on our mind, even if it is in our short-term care. We not only comply with all the standards that we have imposed on ourselves and others have, but nevertheless go above and beyond. The frontline Border Patrol agents and CBP officers do absolutely everything we can to assure their well-being while in our custody.
Mr. Edlow?
Senator, thank you. The Department of Justice's role in this process is to enforce the laws that Congress have passed. Certainly, if Congress amends the law to take that into account, we will enforce those laws, but I can't speak specifically. I'm not able to speak specifically to the reports themselves.
Well, I would like to follow up, Mr. Chairman, with all of you to get a sense of what sort of analysis has been done by each of your agencies to take a look at this, and I'm going to propose for the record, if I may, Mr. Chairman, a letter here signed by, I think, over 1,200 professionals and healthcare officials who believe that any kind of detention, even short-term detention, can have significant impacts on children. Certainly, I would hope that this is something all of you would take a look at. And I think we've got to find out who exactly is even considering this as these proposals come forward. From the testimony I've heard today, it doesn't sound like anybody is giving any kind of comprehensive, thoughtful analysis of this situation. Thank you, Mr. Chairman.
Without objection, that will be entered in the record. And by the way, while you were talking about asylum claims that have been granted, I do have a chart which I'll enter in the record, and we have staff making a copy and distributing it. But just give you the 10-year averages. 25% of asylum claims were granted, 28.2% were denied, 30.8% other closure rates, and that is abandonment, not adjudicated, other or withdrawn, and then finally administrative closure rate 16%. And there are some trends involved in here too. The actual denial rate has actually spiked up in the last couple of years. So again, we'll take a look at this, but again, that's just asylum, and as Mr. Albence was talking about, is some people don't claim asylum, and they get removed or get a removal order as well. So there's a lot of information, a lot of data, and that's what we're trying to do, is try and accumulate all of it so we can get the exact picture of what's pulling off. With that, it's Senator Langford.
Thank all of you for your work and for what you're continuing to do to keep our nation safe. We appreciate that very much. You are carrying out the law and what you've been asked to do, and there are a lot of families across the country that are incredibly grateful for the work that you do in that. Look, I'm going to get a couple of definitions here. The number has come up over 90,000 family apprehensions. Is that 90,000 individuals total, or is that 90,000 families, not families, but we don't know what the number is within that family? Let's do a clarification there.
Thank you, Senator. Actually, for this fiscal year, CBP apprehensions both at the ports of entry and between the ports of entry through August is now over 130,000 family units, and that is actual individuals that make up.
So 130,000 individuals that came as a family unit coming through.
Yes, Senator.
Do we know how many actual families that is? So does that represent 75,000 families or groups of individuals, or you just have a number that's broken up 130,000?
It's more typically broken out in the manner which I just mentioned, but we can get back to you on that, Senator.
That's fine. How do you determine family relationship there? As you've already mentioned before in your prior testimony, there are adults that are coming across the border carrying a child with them or bringing a child with them so they can say they're a family unit. How are you determining who is a family unit and who is not?
Well, thank you, Senator. We're using every resource at our disposal. So not only our biographic and biometric databases, our interviews with the actual families themselves. If they are not carrying documents, we will reach into the consulate contacts that we have also, our colleagues throughout the law enforcement community, and again, leaning on the behavioral analysis and skills of our frontline agents and officers to make those determinations, ultimately, whether or not the family unit is in fact, or the parentage that's being claimed is in fact a valid one.
Do you have to resort to DNA testing at times to be able to determine that?
We don't do DNA testing at the border, sir.
So is there an additional penalty for an adult bringing a child with them, claiming to be a family member, but then you determine this is not actually a family member, this is them trying to be released in the country? Is there any additional consequence for that individual adult?
Well, typically, yes, Senator. So if we find that fraudulent claim be made, then we will refer that individual for potential prosecution, as well as, of course, take great care, as I mentioned earlier, of the safety and well-being of the child.
Because at that point, that child's being trafficked or that child's being used by the adult for whatever purpose to be able to try to get across the border early, then we've got to actually try to find their family.
And those are the determinations that, again, uniquely case by case that were subsequently made and that are investigated. So whether or not it was a trafficking organization that was simply trying, to gain profit, as many of them will do, in marketing themselves to these migrants to take this very dangerous journey, or whether or not it is a serious and or more, alarming case at times of human trafficking, those are subsequently then investigated both by ourselves and our colleagues at ICE to make those determinations. And then, again, as you asked, determine what end state and or disposition we will collectively have with the individual that's found to be, perpetuating these illicit acts.
Okay, thank you, and thank you for the ongoing work that y'all are doing all the time in that for those kids and those families. We talked about push and pull factors some today. Over the last 3 years, the United States Congress has allocated about $650 million in economic assistance for the Northern Triangle, for economic investment there to be able to increase jobs, for anti-corruption efforts, for criminal justice efforts to try to help reduce the crime rate. The murder rate has dropped some in the Northern Triangle. There has been some economic development that's there, but we have made tremendous investments of around $650 million a year each year into the Northern Triangle to be able to help them have a more stable environment that people aren't having to flee. At the same time, I'm concerned about the pull factor here because most of the children that are coming as unaccompanied minors and many of the individuals that are coming as family units are coming because there's a family member already here. Is it our policy currently, if there is a family member already present in the United States, even if they're not legally present in the United States, that unaccompanied minor can be placed with someone not legally present in the United States?
Those determinations are made by HHS, but I can tell you that the policy of that agency is the immigration status of the sponsor is not relevant to their determination as to whether or not a child can be placed in that household, which from our data that we've seen just recently, you're looking at close to 80% of the people that are sponsors or household members within these residences are illegally here in the country.
So that has not always been so. If you go back 15, 20 years ago, if someone came into the country illegally as a child, they were not placed in a home of someone who was also didn't have legal status in the United States. The sponsor had to be someone who had legal status or was a United States citizen if you go back in time. So my question is that a reasonable standard to be able to have and to be able to go back to is that we do not have sponsors that do not have legal presence in the United States?
You're getting me way out of my lane here, because that's really an HHS decision. I wouldn't want to weigh in on how they manage their resources.
Mr. Perez, what effect do you think that would have on the pull factor?
Thank you, Senator. I think, from CBP's perspective, pecking away at any of the potential pull factors that we're seeing that create this spike of movement, one that is, again, wrought with danger, wrought with exploitation, wrought with abuse and abandonment at times, is something that we're interested in seeing. Again, as Mr. Albin suggests, it really is HHS to answer, in depth the question that you're posing. But I think a very important point that I'd like to make from the CBP perspective is that in my opening I talked of the complexity that oftentimes I think gets overlooked of what it is being done at the front line of the border. The national security mission, the trade and travel mission, the drug interdiction mission, the trade enforcement mission, all critical missions that are taxed, if you will, by the surge in migrants.
Mr. Chairman, there seems to be some very obvious things that we can do. Senator McCaskill has brought up again the judges. You've brought up the judges and expanding the number of judges. I think it's something that we really need to continue to be able to press in on and to say we've got to have a faster adjudication and due process than 2 years, 2.5 years. One of the issues that we've got to address is this issue about sponsorship. We tend to, quote unquote, lose children when they go and are placed in a home with someone who's already not legally present, who's been living under the radar for years, and then we're surprised when they both disappear. That shouldn't surprise us. That is something, if we're going to take care of children, we've got to find a way to be able to take care of children and not put them in the home of someone who's not legally present here. But that also discourages people from saying, you're 14 years old, your dad is already in the United States working, it's time for you to go join them, and encourage that activity and that connection point. And the last thing we haven't talked about is the licensing of the facilities. And I'd like to be able to do some follow-up on that because the Flores Agreement requires a licensed facility, but that has been quite a barrier to actually get licensed facilities from a state for a family facility. And I think it's created an artificial barrier for us. And I'd like to be able to follow up on those in the days ahead.
Okay. Well, I appreciate that. And again, I think there are some pretty common sense things that we can all agree on to start solving this problem. But we do need to agree on the data. You talked about children. 70% of the unaccompanied children are male. 70% are 15 or older. They're not 3 years old. The other thing, Mr. President, I want to talk to you because we've been tracking this very carefully, month by month for a number of years, family apprehensions between the borders. So again, this is our blue chart here. And you responded to Senator Langford, there was 130,000 individuals between the borders and at the ports of entry through August. We've got 90,000 family units between the borders. So again, I want you to check, because again, we've been tracking this very carefully. I think potentially, my guess is 130,000 family units. Average number in a family is 2.1 is what we have from DHS. So if you kind of check that, because again, we need to make sure that we're actually talking about the same things, we're using the same figures. Okay, so maybe you can have something behind in terms of what you just told Senator Langford. Senator Hassan.
Thank you, Mr. Chair, and thank you and Ranking Member McCaskill for holding this hearing. Thank you to all of the witnesses for being here today, and to the members of law enforcement represented here today. I want to thank you for your work. I had the opportunity to visit some of the ports of entry that CBP runs last spring to look at your efforts around drug interdiction, and we are very grateful for the hard work and risks that your officers take. I wanted to get down to what I think Senator Peters began to get to, which is what this hearing really is all about. What this hearing comes down to for me is whether the federal government should be keeping children in detention indefinitely while waiting for a judge to review their case. We are talking about the indefinite detention of children. That's frankly not who we are as a country, and it's not what the United States should become. Senator Peters referenced the American Academy of Pediatrics. It strongly opposes long-term detention of children. A March 2017 report from the Academy notes that such detention, and this is a quote, can cause psychological trauma and induce long-term mental health risks for children, close quote. The report goes on to say that detaining children can lead to physical and emotional symptoms such as post-traumatic stress disorder, suicidal ideation, behavioral problems, and difficulty functioning in school. I'm going to ask both Mr. Albans and Mr. Perez just to clarify your answer to Senator Peters. Are you aware of that report from the American Academy of Pediatrics? First, Mr. Albans.
If I could just clarify, we don't have indefinite detention.
My question is, are you aware of that report from the American Academy of Pediatrics?
I think I've seen media reports on that report.
Okay. And Mr. Perez?
I am not, Senator. The age of someone else in the agency may be, but I am not.
All right, thank you. We'll make sure that you get copies of it. In addition to the American Academy of Pediatrics, 2 physicians who work for the Department of Homeland Security came forward in July as whistleblowers. They had both visited detention centers housing children that provided an appalling lack of care, including finding, and this is a quote, an infant with bleed of the brain that went undiagnosed for 5 days. Those same physicians stated publicly that detaining children risks permanent psychological harm, placing children at risk of post-traumatic stress and depression later in life. So again, Mr. Albans, have you seen these statements from these DHS whistleblowers?
I don't believe I have, no.
And Mr. Perez?
I have not, Senator.
Beyond the pediatricians and the whistleblowers, Immigration and Customs Enforcement itself set up an advisory committee of subject matter experts to review family detention. And here's what the agency's own advisory committee found. It said that DHS should, quote, discontinue the general use of family detention, and that in cases where detention was absolutely necessary, families should be detained for, quote, the shortest amount of time possible. Now, given that it is DHS's own findings, I'm going to assume that you guys are familiar with that. Mr. Albans, given these findings from the American Academy of Pediatrics, DHS whistleblowers, and your agency's own advisory committee, why does Immigration and Customs Enforcement continue to support modifying the Florence Agreement to allow for the indefinite detention of children?
Okay, as I previously stated, we do not have indefinite detention. The Supreme Court has ruled on that.
But you are recommending the modification or overruling of the Flores decision, which would allow the indefinite detention of children.
Again, there is no indefinite detention of children. People are detained, and just
right now there isn't because the Flores
but again, our
agreement.
If you let me answer, please.
Excuse me, but I have limited amount of time here. And what I'm trying to get at is you are all here saying, or 3 of the 4 of you are here saying, that you want us to allow the federal government to do something that the Flores Agreement does not currently allow. So I understand your current position. But why are you here recommending a set of changes that would allow the indefinite detention of children?
Okay. What we are doing in this regulation is implementing the process as contemplated by the court in its ruling, which was requiring the licensing of that children could be held in licensed facilities. We have been unable to get state licensure in most places. What we have requested and are proposing underneath this regulation is to establish a federal licensing scheme which will be similar and mirror to what we currently utilize in our standards that would enable us to have the authority to hold these individuals. There's no one is arguing there's not a humanitarian crisis. I think the numbers show it.
Mr.
The humanitarian crisis also.
I have limited time, so I'm going to ask you to stop for a second, because what I'm concerned about is your own agency says that there shouldn't be indefinite or long-term detention of children, that it should be as short as possible. And instead of going towards the remedies that could help us, some that Senator McCaskill suggested, some that you've heard from other members of the panel suggested, instead of going towards those remedies to deal with the immigration surge, you are instead recommending something that experts in child development and welfare ask you not to do in your own people. Now, I want to go on to Mr. Perez. Why does CBP continue to support indefinite detention of children?
Thank you, Senator. I will respectfully just explain that from CBP's perspective, the modification of the Flores Agreement is more so a deterrence and/or the ability to help deter a myriad of pull factors that exist throughout the entire immigration continuum, if you will, by creating a legal framework that does not create disparity in the treatment of single adults and/or family units.
Thank you. Because, again, I'm running out of time, I will follow up with you further. First, I'm going to suggest our office will get to you the various reports about the impact of on children of long-term, any kind of detention. Earlier this year, we were faced with a humanitarian crisis that President Trump created on our southern border. The administration decided that the best course of action was to forcibly separate thousands of children from their parents. That was an affront to American values, and Americans all across this country from all walks of life objected to it. And now the proposed solution that I'm hearing today is to keep children in detention indefinitely. We know that that is harmful to these children, just as forcibly separating children from their parents is. Pediatricians are telling us, DHS whistleblowers are telling us, that based on the conditions they're seeing on the ground, that this is wrong and bad for children, and the Immigration and Customs Enforcement's own advisory committee is telling us that. Not to mention that any parent can tell you how harmful detention and separation is to children. I won't support this committee moving forward with this legislation that allows the federal government to indefinitely detain children. I encourage my fellow members of this committee and fellow members of the Senate to do that. We have heard lots of suggestions of important and practical ways to deal with the backlog and to make sure people come forward not only for their first hearing, but also for all subsequent hearings in the immigration process. But it is absolutely unacceptable to detain children and to have the United States of America, the strongest, best country in the world, treat children this way because we don't want to do other things that are more difficult. That is not who we are. We are stronger than that, we are better than that, and we are far more capable than that. Thank you, Mr. Chair.
Thanks, Senator Hassan. I do want to give Mr. Elbins a chance to talk about indefinite. But from my standpoint, I don't want to see indefinite detention. I don't think that's what we're asking. What we're saying is, give ICE the ability to detain longer than 20 days so that they don't have to make a gut-wrenching decision. Is that the father, or is that the sex trafficker? Is that his daughter? Is that the victim? Because they can't determine parentage in 20 days. So the whole point would be to provide the resources so that we can adjudicate those claims as quickly as possible. Those family units that seem eligible for asylum, that's where you do some kind of alternate to detention. Those that really have no valid claim that looks pretty much like they're going to be removed, remove them as quickly as possible. So again, I'm certainly not supporting indefinite detention. I don't think that's really what ICE is trying to do with this administration.
Mr. Chair, respectfully, without deadlines, without caps, without ceilings, detentions can become indefinite. We are already seeing and hearing from these very witnesses how long it takes for those who aren't in detention to be heard because we can't get around to hiring immigration judges or trial attorneys fast enough, or paying them enough, or resourcing it enough. And as soon as we license detention facilities that allow children to be detained for longer, they are going to be, by definition, in indefinite detention.
So again, some limits on that are something I'm more than happy to discuss with you. Okay, I think it'd probably be a reasonable proposal. Senator Heidkamp.
Thank you, Mr. Chairman. I think the common interest for everyone here is, number one, children. So if we could just kind of take away all of the layers and say we're going to focus on keeping children safe. These children had no choice on whether they were going to come to the border. They were brought by their parents, and now we have a situation at our border where people have legally applied for asylum, and we're going to have to decide what's going to happen. Now, what I will tell you is this movement towards more permanent detention, if we're going to call that, of minors, what would recommend us that we do that when I look at our current record of what's happening to kids in detention? So let's just for a minute say that we're going to basically allow extended detention of children. I have a couple questions. I raised this issue last time we were all here on the Permanent Subcommittee on Investigations, the issue of sex abuse, sexual assault, and rape of immigrant children who were detained in facilities under the contract of the federal government. Where are we at with investigating those? Where are we at of reviewing our contractors? So we have this problem already that's been well reported and well documented. Now we're going to put more children in harm's way? So where are we at with these I think maybe for the Department of Justice, we'll start with you. This problem started with you. I think we all know that. Started when you decided you were going to separate kids at the border. Now we have all these kids that we don't know what to do with, and we can't find their parents, or their parents may have left without them. And they're in facilities where they're being abused, sexually assaulted. Whose responsibility is to fix that problem and investigate it and prosecute it?
Well, Senator, if I may start, I'm not sure I agree with the premise that the problem started with the Department of Justice. The Department of Justice issued a memo that was a memo involving prosecutorial exercise. So what the department was doing was stating that the federal prosecutors along the southwest border would be prosecuting and would be accepting referrals for prosecution from the Department of Homeland Security matters involving unlawful entry under 1325A of the Act, which
I'm more interested in what you're doing to investigate instances of sexual assault and otherwise abuse of children in our custody.
Senator, I would defer to the Department of Homeland Security and Health and Human Services. I can't speak to what the Department of Justice is doing on, especially if it involves ongoing investigations.
Do you think it's a federal crime if they're in a federal facility, federal contract facility?
Senator, again, I wouldn't be able to.
You should figure that out. You know, I think it would be appropriate to at least ask the question of who has jurisdiction. So maybe we'll turn to Department of Homeland Security. Who's investigating these claims, and can we expect indictments and prosecutions anytime soon?
I'm not aware of any allegations regarding sexual assault in any of ICE's FRCs.
Okay. You know, maybe we're looking at federal government facilities. Mr. Perez, can you help me out here?
Thank you, Senator. Our Office of Professional Responsibility is looking into the allegations, some allegations, relatively small number of allegations when you consider the nearly 500,000, again, annually, inadmissibles that are temporarily detained in facilities that are meant to only hold people no more than 3 days, nevertheless comply with the Prison Rape Elimination Act standards, comply with our own transport, escort, and detention standards. And as I mentioned earlier, quite typically, not only designed for short-term detention, but our frontline agents and officers go over and above to make sure that we are complying with all those standards. And we are vigorously looking into the allegations made, and we're glad to share with those outcomes once those investigations are
complete. And out of fairness, we're talking about what we're going to do to try and resolve this issue of separation of kids which, you know, it's the catch-22. I will acknowledge what the chairman is saying. We want these kids to be kept with their parents. The American public wants appropriate reaction to people who are seeking asylum and not letting people, you know, get a free pass in because they show up with a kid. I get that. I get that we have a challenge here. But a common purpose should be preventing children in our custody from being abused either physically or sexually. And the person who's not at the podium today is HHS, right? But yet they're the entity and they're the organization who's going to be responsible for some kind of extended detention of children and families. So we're caught in this spot where we're trying to figure out how we can best enforce our law, and we all agree that that should happen, and how we can protect kids. And it's always the kids that seem to take a back seat here. And I don't think that's right, and I don't think it reflects American values. I don't think it reflects the values of who we are. I don't care if you're a Democrat or Republican. No one thinks kids should be put in harm's way. But yet the fact that the Department of Justice doesn't know if that's a federal crime, if it occurs at a federally contracted facility, that's disturbing to me.
Senator, what I would say is if there is an investigation and there are allegations and that's referred to the appropriate U.S. Attorney's Office for prosecution, then based on those facts, the U.S. Attorney's Office will make the determination whether prosecution is appropriate.
Do you think it's appropriate to investigate contractors where this has been systematically revealed and discussed and reported?
I would, again, if Department of Homeland Security, if CBP is reviewing this through their professional responsibility component, certainly if they bring the Justice Department in, then we can.
I'm out of time, but I will tell you this. Until someone tells me how they are going to be better regulated and how we're going to get these facilities into compliance so that children are not abused, either sexually or physically, it's going to be really hard for us to expand any kind of detention jurisdiction. And so it's really important for me to understand how we are going to create a systemic system of protection of children, whether they're detained for 2 days or 3 days in an ICE facility, whether they are, you know, basically part of the apprehension process, or whether they're part of a longer-term detention I call it foster care system that the federal government through HHS is advancing. And these are not partisan questions. These are questions we need an answer to before we move on any additional scoping of detention. Thank you, Mr. Chair.
And Senator Heidenkamp, Senator Jones has yielded to Senator Daines. Senator Daines.
I want to thank Senator Jones, too, for yielding. Thanks. Thank you, Mr. Chairman. And I want to thank the witnesses for coming here today for the very important work that you do for our nation. As we know, the reinterpretation of the Flores Settlement Agreement is at the crux of this catch and release policy for apprehended families. Flores presents a significant hurdle to the enforcement of our immigration laws. We need a solution that secures our border, upholds the rule of law, and accomplishes these goals without separating children from their parents as a default policy. And the administration has made it clear that Congress must act, and I heartily agree. I'm a father of 4, raised 4 children. I understand the importance of keeping families together. I also understand that the rule of law is a fundamental part of the foundation of our nation, and it also needs to be protected. I helped introduce 2 bills that address family separation at the border and to offer a fix to Flores. That's the Keep Families Together and Enforce the Law Act, as well as the Protect Kids and Parents Act. Both of these bills would require families to remain together while the adults who illegally cross the border face legal action. Furthermore, these bills would authorize additional immigration judges and provide mandatory standards of care for family residential centers to ensure suitable living accommodations. Mr. Albans, you listed some specific legislative changes that are needed to close the loopholes in our immigration system. How would fixing Flores better allow ICE and law enforcement to do their job?
Unfortunately, I'm limited to what I could speak based on the fact that the The rule is out there right now for public comment, so I'm limited as to what I can say with regard to the rule and kind of have to limit my answers. I can tell you from an enforcement perspective, the transnational smuggling organizations that are bringing these people to the country are very good at messaging to the individuals in the Northern Triangle and these other countries that if they come to the United States as a family unit, that they will be processed quickly and released, and they never need to appear for court. They never have any repercussions for what they have, and no one's going to be out there looking for them and finding them. That is why you have a continual surge of individuals coming to the border. When we, in 2014, created family detention, we saw a marked drop of almost 40%, I believe, in the number of apprehensions by CBP because of the fact that there were consequences to that illegal activity that these individuals were engaging in.
Just yesterday, the Senate passed legislation that will help combat the meth and opioid crisis in our country. Before the vote, I went to the Senate floor and I spoke about the devastating effects of meth and opioid use is having in Montana. We've seen drastic increases in meth and heroin use in Montana. In fact, from 2011 to 2017, there was a 415% increase in meth and a 1,234% increase in heroin found in controlled substance cases in the state. Furthermore, we've seen a 375% increase in meth found in post-mortem cases during the same time frame. Keep in mind, Montana is a long ways away from our southern border, but those drugs are coming through our southern border. Mr. Perez, as you point out in your testimony, the increasing numbers of individuals held in CBP facilities divert CBP resources from addressing a number of serious threats to our nation, including transnational criminal organizations and dangerous narcotics that are wreaking havoc in places like Montana. CBP has a vast mission. I understand it's often a balancing act with limited resources. My question is, how do we ensure that stopping the flow of illicit drugs at the border remains a top priority, and how do we better prevent these drugs from reaching communities in places like Montana?
Thank you, Senator. First, I'd like to absolutely tell you that it is, for CBP, a absolute top priority amongst the complex mission set that we have. That is to stop this terrible scourge of not only narcotics in general, illegal narcotics being trafficked by these transnational criminal organizations across our border, but in particular, the two you mentioned, the ongoing synthetic opioid crisis, that with fentanyl and other synthetic drugs like meth. This is, again, an ongoing daily challenge, one that we bring all our resources to bear, again, all the training and expertise of our agents and officers, the technology that we have at our disposal, our canines, and our advanced information, our targeting techniques, again, working alongside our investigative arm and ICE to dismantle as well, subsequent to seizures, these transnational criminal organizations to the best degree we possibly can. That is why I circle back with this particular topic, CBP's particular interest in what it can possibly and probably do with respect to eliminating a pull factor. We just as soon see those numbers of illegal migrants drop. People, again, not choosing to take a long, arduous, and sometimes very dangerous journey that also exposes them, again, to being exploited by human trafficking organizations, by other criminal elements, and frankly, again, criminal organizations that have only profit in mind, and then these folks end up becoming victims themselves, even more so than where it is that they're fleeing from. And so that is why it is so critical for us that these loopholes be addressed in order to bring those numbers down as far as what is actually arriving at and or between our ports of entry.
I think it's important because it's a zero-sum game here. Every moment you're spending here addressing this issue of the illegal crossings is time spent that could be used to stop the flow of illegal drugs.
Thank you, Senator. And as I mentioned earlier, legitimate trade and travel, national security concerns, pests that threaten our agriculture, our economy. Those are all amongst the myriad of missions that CBP has, including dealing with migrants, which we do as humanely and as caringly as we possibly can, particularly when children are involved. So it is a delicate balance that we strike every day.
Mr. Albans, thank you, and thanks for your work to secure our borders. Mr. Albans, if I want to know if alternatives to detention work.
Alternatives to detention are a fairly effective tool at getting people to appear at some or all of their immigration court hearings. It's a woefully ineffective tool at actually allowing ICE to effectuate a removal order issued by an immigration judge.
Like ankle monitors, for example, effective or not?
Again, getting people to a hearing, they're fairly effective. Actually enforcing a judge's removal order, they're woefully ineffective.
Last question. Has the implementation of the MOA helped ICE remove criminal aliens?
Are you talking the MOA with regard to HHS and the fingerprinting of sponsors?
Yes.
Yeah. We've arrested 41 individuals thus far that we've identified pursuant to that MOA. Our data that we've received thus far indicates that close to 80% of the individuals that are either sponsors or household members of sponsors are here in the country illegally, and a large chunk of those are criminal aliens. So we will continue to pursue those individuals.
Thank you.
Senator Jones.
Thank you, Mr. Chairman, and thank you to all of our witnesses for appearing here today on this really important topic. My question, I want to talk a little bit about procedure to Mr. Albans and Mr. Edlow. Are you familiar with the 2016 study that the ABA did that said immigrants with counsel are 5 times more likely to win their cases than those without counsel? Are you familiar with that, Mr. Albans?
I may have seen some media reporting on that, but I can't say I'm intimately familiar with the report.
Mr. Edlow, are you familiar with it?
I've seen some reporting on several studies of that nature. I can't speak to that specific one.
Well, it seems to be important because if that study, and I have no reason to doubt that study, that immigrants that have counsel are 5 times more likely to win their cases, I think it's a testament to who is crossing the border and why. And we may be sending folks and deporting folks that have legitimate cases simply because they don't have access to counsel. So my question for both of you is the Department of Justice and is Homeland Security doing anything to try, are you taking into account in your processes the ability of folks to be able to get counsel? Because right now there is no constitutional right to counsel. They either have to get a pro bono counsel or try to get retained counsel, which is difficult to do. So is the ability to get counsel come into any factor in your considerations?
Thank you. Yes, actually, we have a very extensive legal orientation program that we work with many non-governmental organizations to provide legal counseling and pro bono counseling to our detainees. We actually have them on site in our family residential center in Dilley, Texas. They actually have office space, and one of the first things that the aliens that are booked into that facility experience is that legal orientation program. And they have private rooms to meet to go over their asylum claims before they speak with the asylum officers from CIS. Any individual that we arrest, families or otherwise, that we take into custody, we provide them with a list of free legal services and other opportunities for which to avail themselves.
All right, so if you get more lawyers, and I'll come to you real quick, but if you get more lawyers, you mentioned more lawyers to prosecute these cases, will you also try to expand the legal services ability for these immigrants that are coming in?
We'll certainly do whatever we can to provide individuals with legal orientation programs that they want to avail themselves of.
All right, Mr. Adler.
Thank you, Senator, for raising this topic. With regard to counsel, as I'm sure you're well aware, the immigration laws do not allow for government-funded counsels. Certainly, if Congress wishes to change the law, Congress is free to do so, but certainly at this stage, the government cannot provide counsel. The role of the immigration judge during the immigration court proceedings is to ensure a fair hearing for both sides. And oftentimes, that means that the alien is unrepresented. The judge has to step in and ensure that the alien is getting their entire claim out.
But that also bogs down the process. I mean, my experience is that in court proceedings, almost 40 years of practice now, that people that are represented by counsel, the proceedings move in a better pace and much more efficiently. Wouldn't you agree with that?
I would, but I would also note that if you've got to make sure it's an immigration lawyer that's coming to the proceedings on behalf of the alien, because a lot of times when pro bono counsel come in, there's a learning curve at that point that they need to figure out. But what I'm saying though is, in these instances, first of all, the judges give, when necessary, continuances to allow respondents to seek counsel. That's both detained and non-detained get time to seek counsel, especially non-detained get a significant period of time. Depending on the city where the court is, it could be several months. But ultimately, if the judge decides that the case has to go forward with the respondent unrepresented, there is painstaking process that is taken to ensure that alien gets a fair hearing and that those claims are fleshed out to the degree that they need to be.
Well, wouldn't you agree, though, that someone that is being detained has a harder time trying to retain counsel than someone who is not detained? And so is your proposed rules that we're talking about now, does it take into account the ability to get counsel?
Well, those are two separate questions. Let me take the second one first. Okay. Just so you're aware, the Department of Justice is not a party to the proposed rules. Right. So I can't comment on those rules, especially as we're in the middle of the notice and comment period. In terms of the attorneys coming into the courtroom, though, there are a significant number of organizations that regularly go to these detained facilities to make themselves available to detained respondents. And that may include themselves representing these respondents. It may also be that they put these respondents in touch with other available pro bono attorneys. So there is, frankly,
there's a process in place.
There is a process in place. I think in a lot of cases it may be easier for a detained individual to meet with a pro bono attorney or meet with a legal organization that is looking to provide pro bono services than a non-detained alien.
All right. Well, I would encourage all parties to try to do what they can to ensure a swift ability to get counsel, because I think it will speed up the process. It will help the process, and particularly consider doing more to get these children advocates or guardian ad litem throughout our court system. No matter if a child is injured or whether it's a part of an adoption proceeding, they always have guardian ad litems to protect their interests, which I also think would help protect their safety. The last thing in the remaining time, Mr. Edlow, I'd like to talk about the filing system that you guys have. Back in over 30 years ago, the federal courts went to electronic filing. In 2001, EOR also decided that they would go back they would implement an electronic filing system. But as of today, it's still not out there. We're still dealing in the dark ages like I do with paper. I have books instead of my iPad sitting here. But look, I've been practicing law a long time, and I know how efficient it can run when you have an electronic filing system. What's going on? Why the delay in what every court in America is doing these days to speed their process and make it more efficient?
Senator, thank you for your question. You know, I can't speak to what previous administrations did or did not do, what action they were able to take to move this along. I can tell you from personal experience practicing in immigration court for many years, it would have been very helpful to have an electronic filing system. And I can also tell you that EOR is working very hard to get a pilot program out there and to figure out, get the kinks worked out so that we can do a nationwide rollout.
Have you got any kind of timeline on that?
Senator, I would get back to you on that. I would want to speak to the folks who are handling it at EOR to make sure that I get you the right information.
Great. Well, please do for that. Thank you very much, Mr. Chairman.
Senator Harris.
Thank you. And Senator Jones, I actually have a piece of legislation, the Access to Counsel Act. I couldn't agree with you more. These folks should not be denied access to counsel when they arrive. Mr. Albence, to follow up on questions you've been previously asked by my colleagues regarding the position of medical experts, including the American Pediatrics Association and the American Medical Association, you told us in July, I believe, quote, with regard to the family residential centers, I think the best way to describe them is to be more like a summer camp. When pressed on this statement, you said that you, quote, were very comfortable with the treatment of the immigrants at these centers. Do you stand by that statement?
Absolutely, I do. I just
you
came
believe
back,
they're like summer camps?
I believe the standards under which they are kept are very safe. They're humane.
Have you ever sent, do you have children or do you know children that have attended summer camp? Would you send your children to one of these detention centers?
Again, that question is not applicable. What I can tell you is that I went to a CODEL there just 3 weeks ago with Senator Boozman and Senator Capito, and what we saw there were children receiving excellent medical care. We saw children playing in the gymnasium. We saw families sitting at computers in a library that was well stocked. We saw a cafeteria that was spotless with unlimited amounts of food with regard to when they eat. They live in dormitory settings with televisions, Xboxes, and a host of other recreational opportunities.
But you can understand the concern to suggest it's like a summer camp would suggest that a parent would voluntarily send their child to a place like that to have a good time for the summer.
Well, you're missing, but the point is, the parent made the illegal entry. The parent put themselves in this position. They made the illegal entry into the country. That is why they are there.
You're here because this is an oversight committee hearing. So I'm asking you specific questions to gauge your ability to actually conduct oversight over the operations of your agency. Moving on. Mr. Perez, I'm sure you're aware of the great public outrage at seeing images of young children at CBP custody in large metal detention cages. They apparently have been given Mylar blankets and camping pads to sleep on concrete floors for multiple nights. Since the President signed the executive order on June 20th, 2018 regarding family separation, have any families been separated at the border, and if so, how many?
Thank you, Senator. We are not separating families at the border, at or between the ports of entry. As I mentioned earlier, the temporary detainment facilities that are run at the ports of entry, run by the Border Patrol, are meant for short-term holding. And the men and women on the front line of CBP go above and beyond not only the imposed standards on maintaining the sanitary, the healthy conditions, and the care of those in our custody, family units, and adults and children.
So I just want to be clear that we're thinking the same thing. I'm asking, are you saying then that no families have actually been separated since the executive order was signed on June 20th?
The only instances in where families would be separated is if there is an element of false parentage, a criminal situation with the actual adult and the child, a health concern or a safety concern for that child.
Do you know how many such cases there have been since June 20th of 2018?
We could get back to you on that, Senator, but again, those would be the only circumstances, again, with the safety and well-being of the child first and foremost on our mind, where a family would be separated.
So other than that, there are no families that have been separated since the signing of that executive order?
Yes, ma'am.
And then, Mr. Albenz, I've asked repeatedly for information on the number and the status of any cases, if they exist, where your agency has referred an adult who accompanied a child to prosecution for trafficking. And I've still not received that information. So in your briefing, I'm sure you're prepared to answer the question because I ask it every time. How many cases has your agency referred to the Department of Justice for prosecution or even investigation of trafficking, since that appears to be the basis for some of your policies, a concern that trafficking exists?
So thus far, Homeland Security Investigations within ICE has initiated 778 human trafficking investigations, has made 1,410 human trafficking arrests, criminal arrests, has obtained 759 indictments, and 425 convictions.
Since what date is that?
That's this fiscal year up through August 31st.
And are those cases where the concern was that an adult who was accompanying a child, because that's the specific question, adults who are accompanying a child who arrive at our border, how many of those cases have been referred for trafficking prosecution?
We would have to get back with you on that. We'd have to go look in our records to see.
Okay, when can I expect to get that information?
I wouldn't think it'd take more than a couple of weeks.
Okay, so by the end of next week. Is that doable?
I'll go back and talk to, I'm not quite familiar with the ICM and how searchable it is, but once I find out, we'll certainly let you know.
Okay, I appreciate that. And also, and I don't know if it's either Mr. Albence or Mr. Perez, whichever, or if both of you can answer this question, but I'm assuming that you're both aware that there are affidavits that have been filed this summer alleging that children faced limited access to food and water and experienced spoiled food, freezing temperatures, and verbal and physical assault in CBP custody. Mr. Perez, are you aware of that?
Thank you, Senator. We mentioned earlier our Office of Professional Responsibility alongside DHS's Office of Inspector General have been investigating any and all of those allegations of misconduct. We take those investigations and those allegations very seriously, as we do with any other allegation of misconduct by either contractors or employees. Nevertheless, very confident that given the amount of intake and allegations and cases that there are versus the nearly, again, almost 500,000 admissibles that we are detaining and encountering, that the instances with which this is occurring are relatively modest, and that, again, our frontline agents and officers are doing the best they can to take care of these folks.
Thank you. I have just a few seconds left. I've asked on both April 22nd and May 15th DHS officials about CBP employee training as it pertains to the handling of children, as well as training that pertains to the handling of the youngest children in your detention facilities, and I've not received a response. Can one of you tell me where that information is, or if it exists at all? And that is what you're doing to train your employees who are having direct contact with children and their parents on how they should be approached in the least traumatic manner.
Absolutely, Senator. We can get back to you. I will make sure that we do respond to you with the actual laydown of the training that we provide, but I can tell you very briefly that our agents and officers annually are required to take training both with respect to potential human trafficking concerns, exploitation of children, and or the care and custody of the children in our temporary detention facilities through our transportation escort and detention standards.
Thank you. And again, I'll note I asked for this information on April 26th and again on May 15th, so I'd appreciate your swift response. Thank you.
Senator Carper.
Thanks, Mr. Chairman. Welcome, one and all. I want to return to a subject that I've turned to many times on this committee, as my colleagues will affirm, and that is root causes. Root causes. And I've long been a proponent of common sense, comprehensive immigration reform to fix our broken immigration system. But it seems to me that a proposal to hold families indefinitely fails to address an incredibly important part of the equation, that is the push factor that leads so many to seek safe havens here in the United States. When I was privileged to serve as chairman and ranking member of this committee, I made any number of trips to Mexico, to Central America, to Honduras, Guatemala, and Salvador, in order to try to better understand the root causes of migration to the U.S., joined by a number of members of this panel, including our chairman and Senator Heitkamp. What I learned on those trips is that many people in those countries live in fear for their lives. Gang violence is, in too many instances, rampant. Government officials are too often unaccountable. And many people have no hope of, or little hope of, a better economic situation for themselves and their families. I think unless we work with our neighbors to the south, continue to work with our neighbors to the south, work more effectively with our neighbors to the south, to address the factors that lead so many to seek safe haven in the U.S., including lack of rule of law, unimaginable violence, the lack of economic opportunity. We're simply putting a Band-Aid on the problem. In its most recent budget request, the Trump administration asked for about $430 million to support the U.S. strategy for engagement in Central America. I think that's less than half of what was initially sought by the Obama administration. It's about almost a third less than this year's appropriation. This occurred despite the fact that some in the administration, including General Kelly and Commissioner McAlealan, have argued for continued funding for this strategy. Thankfully, bipartisan Senate appropriators agreed on the importance of continued funding, and they restored President Trump's cuts. Parents and children facing sure death at home or likely death at home will continue to make this dangerous journey to our borders. Despite nearly any inhumane policy this administration might, or other administrations might pursue. For all the witnesses, this question. Take a moment and react to that. Do you agree that any effective strategy to secure our border must address the root causes of migration? Let's just start with you, Ms. Gambler.
I think that seems reasonable, and certainly through GAO's work, as you've indicated, Senator, we found that there can be a mix of factors contributing to unaccompanied children leaving their countries and coming to the United States, to include both factors in their home countries as well as factors here.
Mm-hmm. Thank you. Mr. Edlow.
Thank you, Senator. Certainly, in terms of the root cause of the migration, you're going to see push and pull factors with what's going on here in this country. We saw that in 2015 when the Flores interpretation came out that included accompanied minors. We saw an increase in apprehensions of families along the border. I'm not saying that's the only reason that they were coming, but certainly that does help. Also, when there appears to be a consequence, there does appear to be a drop in those apprehension numbers too. We saw after President Trump's inauguration that there was a 40% decrease in apprehensions for a period of months. Certainly, there are so many varied push and pull factors that would have to be addressed, and I would just say that the department welcomes legislation to address those, to come up with a more equitable solution moving forward.
Thank you. Mr. Perez.
Thank you, Senator. I believe you mentioned the Commissioner's previous testimony. I can assure you that CBP, alongside our DHS colleagues, continue to invest and put forth a significant effort in working with our counterpart agencies throughout the hemisphere, particularly in Mexico and the Northern Triangle, the creation of vetted units, systems and information sharing, capacity building to the extent of even modernizing and helping them to modernize some of their trade functions to address the different push factors. So that does certainly remain a priority for CBP and something that we're going to continue to put forth an effort on. I would just echo my colleague's comment that you know, with it, for us, it is so critically important, given the entirety of this, as I like to call it, immigration continuum, that it is an effort for the push and pull factors, which are many, that we ever so have, when we ever so have the opportunity to address some of those, to again prevent someone from ever embarking on what is oftentimes a very, very dangerous journey, that we would again welcome those discussions.
Thank you. Mr. Robbins, just be very brief in your response, if you would. So
I would just echo the sentiments of my colleagues. ICE has invested significant resources both on its Homeland Security investigations as well as enforcement and removal operations in the Central American and Mexican regions to help dissuade some of this travel. I will also say I think it is a humanitarian issue, and I think it's incumbent upon us to limit those pull factors that exist to stop people from making this dangerous journey. If individuals in those countries know that they're going to spend their life savings to try to get here and run that risk of going through cartels and smugglers and all sorts of horrific abuse that happens to these individuals on the trip, and that when they get to this country, if they have no lawful right to be here, that they will actually be ordered removed, and that removal order will be effectuated in a timely fashion, that humanitarian issue will decrease significantly because people will stop making the trip, as we have seen before.
Mm-hmm. I don't ask a lot of yes or no questions. I'm going to ask one now. And it's not a trick question. It's just yes or no. That'd be helpful. Would you all support a proposal that provides funding to address the root causes of migration from Central America, which includes ensuring that law enforcement there has the resources it needs to fight organized crime, drug cartels, and gangs? Mr. Robbins?
Yes, sir.
Thank you. Mr. Perez?
Yes, Senator.
Yeah. Mr. Edlow?
Senator, I'm sorry, the department would have to take a look at the legislation and then make a determination whether it could be supported.
Mm-hmm. Thank you. Ms. Gamble, would you care to take a gamble on that one?
Of course, funding decisions are within Congress's authority, but certainly we agree that there are factors in those Central American countries that are contributing to some of the migration.
All right. I'm out of time.
And we do have a vote called, so.
I understand. I have some more questions for the record. I got to just say one thing in closing. We've been funding this Alliance for Prosperity now for, I think, maybe our third year. And the chairman's been down to these same places, sometimes with us together, other times on separate codels. I've watched with interest over the last 20 years what has happened in Colombia, a place that was where, 20 years ago you had a bunch of gunmen rounded up their Supreme Court and shot them all to death. And to go from that point in time to a country that's stable, not perfect, but economically strong and vibrant, and it's actually made a success of themselves. We've helped them. And I always like to say it's like Home Depot. You can do it, we can help. And that's what we've done with Colombia. And that's what we need to continue to do with Honduras, Guatemala, and Salvador. If we do, they can do it, but we need to help. Thank you.
Senator Carper, before you leave, just a couple points. If you can put my blue chart up there for my next question. We have traveled down there, and we've done a lot of hearings, and I think we would agree that it's our insatiable demand for drugs that gave rise to drug cartels and destroyed public institutions down there. We bear responsibility. But I want to ask Mr. Perez real quick. The exact same detention facilities that we were really on a nonpartisan, bipartisan basis praising in 2014 at the height of the UAC crisis, those are the exact same detention facilities that CBP is using to just handle, again, the continuing flow of unaccompanied children and family units, correct?
They are, Mr. Chairman.
Again, they're not designed to keep people in cages for an indefinite period. This is really, you're funneling people through these detention facilities where you delouse them, you provide some additional medical assessment, and try and move them out of there within about a 24-hour period, correct?
As best and as quickly and safely as we possibly can, and effectively, yes.
But again, I just want to make sure, because right now, 2014, we were praising, CBP's efforts. Now we're calling them cages, and they're exact same facilities. Real quick, that chart I think is pretty telling. The picture says an awful lot. And what it tells me is that detention did work. We had Secretary Chertoff in 2008 when he had the Brazilian crisis, where there were 88 apprehensions in 1992. In 2005, because of a number of reasons, there were 32,000. And then Secretary Chertoff really began a process of apprehending, detaining, and removing them back to Brazil. And a year later, there were less than 1,500. The Obama administration kind of recognized the same point. In 2014, we saw a surge in UACs as well as family units that began detaining, with the whole process of those that didn't qualify for asylum would be returned. That really, from my standpoint, it's pretty obvious that worked. I mean, anybody want to dispute that, or it'll just quick get on the line? Mr. Albence, do you believe that detention did serve as an effective deterrent?
I think detention coupled with removal and consequences to illegal activity serves as an effective deterrent. Detention in and of itself is... And
again, no, I am saying detention and removal. Okay, Mr. Perez?
I believe the data speaks for itself, Mr. Chairman, with respect to what it is that can possibly be realized when there is consequences that are delivered for illegal activity.
Mr. Edlow?
Senator, I would echo what my colleagues have already said. Certainly, when there is a consequence, we see immigration flows respond to that consequence.
Ms. Gambler?
We haven't specifically studied the issue to be able to make an assessment one way or the other.
Just as like a sentient human being, I mean, to kind of look at that, you figure something's going on there, right?
I would add more broadly, not just as it relates to families, but certainly, Border Patrol and CBP have implemented programs to apply consequences to individuals who are apprehended crossing the border. And I think the intent of those consequences is in part to address what you're speaking to.
And Mr. Perez, you talked about the perception in Central America. It's way more than perception. It's a reality. The drug cartels, the human traffickers, the transnational criminal organizations are using these loopholes, right? They're talking about, whether it was back in 2012 about DACA, the permiso slips, they're using that, telling individuals from Central America, come on in America and you can stay, and by and large they stay, correct?
And that's why I followed up, thank you, Mr. Chairman, that's why I followed up that with my comment about the perception being at times a reality, that the loopholes that exist by virtue of judicial decisions and or legal loopholes in effect have had and made these perceptions an operational reality by not being able to deliver uniform consequence throughout the entirety of the immigration process.
Mr. Albence, did you basically concur with that fact that whether it's the Flores decision, whether it's the human trafficking bill in 2008, these created a circumstance that is being used and being exploited by drug cartels and human traffickers, correct?
Certainly. Not only does our intelligence tell us that, the individuals that we interview, that CBP interviews, tell us that, but the numbers speak for themselves.
Ms. Gambler, in your testimony you talked about that the administration had actually met its goals in terms of alternate alternatives to detention. That was set at 2,899 out of a population of approximately 40,000 in the program. I mean, that's 7%. It's not exactly a stretch goal, is it?
No, it's not. And those measures, that measure in particular was fairly new when we looked at the program. It had only been in place for about 2 years. I would also add that at least at the time that we were reviewing the Alternatives to Detention program, which was a few years ago, that was measuring removals, and it was counting whether or not aliens who had been in an Alternatives to Detention program at any point during the same fiscal year in which they were removed. I know that Mr. Albence was mentioning some more recent data, and if it would be helpful, GAO would be happy to take a look at that as well. I think there's some intricacies in terms of the data associated with the Alternatives to Detention program and its performance that might be helpful to the committee for us to provide information on if it's helpful.
I would say for preparation of this committee, or for this hearing, all the information I got, bottom line, we need a lot more information in terms of real data on alternatives to detention. Again, it sounds like a good idea, but I think there's some real problems with it that we need to flesh out here. And these types of statistics where 99% show up to hearing, yeah, until they get a removal order, and then it doesn't really behoove them. I mean, it makes a lot of sense. Show up to a hearing, you just might get asylum, but the minute you find out you're not going to get asylum, you abscond. So those are just common sense human behavior. And of course, a very low-level goal. I mean, under promise, over deliver. That's good in business, but I think we need to point out that fact. Final point, the administration is undergoing a rulemaking procedure, and this is really a sales pitch to pass legislation that hopefully the courts wouldn't overrule. They would actually respect the fact that Congress has spoken. But to fix this, the administration is undergoing a rulemaking, which was contemplated in the Flores settlement, correct, Mr. Edlow?
Yes, Senator. Back in 2001, there was a stipulation agreed to and added into the Flores settlement agreement that specifically contemplated the agreement terminating within a certain period of time following promulgation of regulations.
So a couple of laws have been passed. When Congress passed those laws, they probably figured they were taking care of the Flores settlement. The courts haven't recognized those laws, basically, correct?
That's correct. Specifically TVPRA, and had it said this is enacted to terminate the Flores settlement agreement, it probably would have at that point.
Okay. I guess my final point, and this is why I think Congress has to act, and I know you really can't answer this, but I'm going to ask you to anyway. What do you think the probability is that when the administration issues a rule on this, going through the process, the Administrative Procedures Act, that it's going to be challenged in court and will not be able to put into effect? It'll basically have the same problem. The courts will overrule the rulemaking.
The department, I really can't comment.
Anybody want to comment that just from a common sense standpoint? I mean, I know my view on that. I mean, it's going to be extremely high probability. The courts will intervene and this rulemaking will never be put into effect.
Senator, I would just add that should the rule be challenged following the notice and comment period, and I'm fully confident that the Department of Homeland Security and Health and Human Services will respond to those comments that come out of this process, the department will stand ready to defend the challenges as they come forward.
But it'd be a whole lot cleaner and a whole lot more certain if Congress would act and pass a law and fix this particular problem, correct?
Certainly, legislation would be preferable.
Okay, that's all I was looking for. And again, I want to thank all of you for taking the time for your testimony, for answering our questions. I think this hearing has definitely been helpful. I think it's moved us forward as a committee. We still have information, and I'm looking forward to future cooperation so we can get all the facts, get all the information, so we can set an achievable goal, which I think this is a more than achievable goal, so we can design a solution on what I would call a nonpartisan basis. With that, the hearing record will remain open for 15 days until October 3rd, 5 p.m. for the submission of statements and questions for the record. This hearing is adjourned.
Hey, Rebecca. Matt Allen, nice to meet you.
Good to meet you.
Take care.